Thank you so much for attending Nonprofit Resource Hub's webinar event today called Work from Home Minefields for Employers. And I'll be introducing Doug Rowe here shortly. But my name is Ellie Hume, and I'm the director of your part-time controller's New York City area practice. We are a proud associate member of the Nonprofit Resource Hub, which I'll be referring to as NRH today. You might be asking, well, who or what is NRH? Well, we're a trade association with a mission to serve, be a resource to educate and communicate, connect its members to the nonprofit community. At the same time, NRH serves the nonprofit sector as a bridge connecting nonprofit organizations to resources and to each other. Well, so you might be asking, well, what do we do for nonprofits? Our main goal is to provide nonprofits with resources to help grow their organizations. We share a directory of vetted, trusted organizations that provide quality products, services, and education to the nonprofit sector. We are continuously adding new associate members, and these organizations go through a rigorous process to ensure their quality of service. We also host networking sessions and events just like this one to foster opportunities for collaboration, both with other like-minded nonprofit organizations and with leaders serving the sector. We are providing information and insight into the nonprofit sector to keep you informed about key issues and resources that exist for your organizations. And we offer expert advice and consultation to help organizations effectively further your missions. And lastly, we serve as a one-stop resource hub for nonprofits, providing a single access point for information. We were founded by five original founding organizations that really aim to serve the nonprofit community. And these five organizations make up our board of directors: Serini and Associates, Certilman Balin, Nonprofit Sector Strategies, Triumph International, and Vanguard Insurance Agency. Today we're encouraging all the nonprofits to join as nonprofit partners if you aren't already. There is no cost for you to join and plenty of benefits. Once you join, you can start enjoying these benefits, as well as your logo and your mission will be posted on our website with a link to your site. You'll be able to add calendars, add events to our calendar so that you can circulate your information amongst the membership base. And we'll also have lots of information. We circulate articles and helpful items posted on our website all the time. And lastly, before we get to Doug, I just want to thank all of our associate members who are part of the organization and help us do the great work that we are doing. PNP Staffing, Premier Payroll Solutions, Powered by Professionals, 5-Star Advertising, Morgan Stanley, Sterling Risk Insurance, Lee, Nolan, and Corrigalin LLC, Certilman, Balin, Adler, and Hyman LLP, and your part-time controller. So, and now let's get on with the program. I'd like to introduce Doug Rowe, a partner with Certilman Balin in their labor and employment group. His broad range of experience includes claims alleging discrimination based upon race, sex, religion, national origin, age, and disability, as well as sexual harassment, wage and hours issues, labor arbitrations, and defense of employment-related claims under federal and state statutes. So there's Doug. Feel free to share whatever else you'd like about yourself, but take it away from here.
Sure. Thank you, Ellie, and welcome everyone. So all employers are obviously aware of employment laws. So they have to pay attention to wage and hour laws, pay their employees properly. They have to pay attention to the laws that protect employees because of a disability under the Americans with Disabilities Act or state law. they have to ensure that their employees are not discriminated against. They have to ensure that their employees are protected in the workplace from a health and safety standpoint. And they have to protect their own trade secrets and their own proprietary information. But the workplace has now changed. So whereby the workplace used to be in offices, now it's also at home. The workplace is substantially different now than it was a year ago. So there are unique aspects to compliance with all these employment laws because of employees working from home. I'll start with the wage and hour issues. When an employee works in the office, they could punch a time clock, they could sign in on their computer, they have a schedule, they have pre-planned break periods, meal periods, etc. They have a start time, they have a finish time. The office opens, the office closes, and that's it. But when employees work from home, employees could have a tendency to work when they want, when they need. They could take longer breaks. They have to take care of the kids. They can run out to do an errand during the middle of the weekday, as long as they feel they can get their work done at night or on weekends. So that's fraught with problems for the employer, because under those circumstances, there's no way for the employer to properly keep track of the employee's time. And why is that important? Well, first of all, they have a legal obligation to track all employees' work time. And they also have a legal obligation to pay for all employees' work time. And they also have an obligation to pay for employees' work time at time and a half if their hours, if the non-exempt employees' hours exceed 40 during a week. So you could see the problems that could arise from permitting employees to work if and when they want during the course of the day. So from a policy standpoint and a practice standpoint, it's important for employers to track the employee's time. It's also important for employers to give the employee a schedule. It could be a 9-to-5 schedule. It could be with breaks, and think about, also ensuring that employees take a mandatory meal period. In New York, for example, every employer is required to give their employees at least a half-hour meal period every day. So that has to be tracked as well, or the employer can be faced with a claim for failure to provide a meal period. And by the way, when you deal with employees, these claims could be not insubstantial, depending on how many employees there are. We've handled cases which result in, class action liability for, failure to provide, the proper overtime or meal periods or break periods, etc. So those are some of the issues that could come up. Establish boundaries for employees. The employer should, and by the way, when we talk about tracking time and establishing boundaries, first of all, it's important for the employer to train supervisors to make sure that the employees are in compliance with the laws and that they're following the company policy. The employer should also have a written policy, a written work from home policy, which sets out, all these legal obligations to, track the time. It's also a best practice because of these issues and because employers can find themselves in a situation where employees maybe, and by the way, let's remember that what constitutes work time is one thing, but employers can be faced with a situation where, while an employee worked during their regular work hours during the day, the employee may want to start responding to emails or preparing emails at night or on weekends. Well, all that is compensable time for a non-exempt employee. So the employer is is reminded to, when I talk about establishing boundaries, instruct the employee, not to respond to emails and not to prepare emails at night unless there's emergency situations, and that could be laid out. And it has to be the exception, not the rule. Again, this is what's necessary in order to protect the employer from potential wage and hour liability. How about this for an interesting issue? And I assume that most employers don't really consider it, but when employees work in the office, employers usually have an expense reimbursement policy. And if an employee incurs an expense in behalf of the employer, the employee is entitled to be reimbursed for it. Well, just like the workplace, if you have working from home, if an employee buys paper, arguably they're entitled to be reimbursed for that paper. There's actually a law in California entitling employees to be reimbursed for a portion of their home phone or cell phone when they're working from home. That hasn't hit in New York, or, I haven't done a survey of other states, but it's an issue. And one of the reasons why it's also an issue, aside from the logical aspect of it, is that if you have a minimum wage employee who starts spending, incurring expenses in behalf of the employer, and the employer doesn't reimburse the employee for these expenses, the employer could find itself facing a minimum wage violation, because the expense incurred by the employee can result in the employee actually earning less than the minimum wage for a particular week where they're spending money on behalf of the employer. So again, it's something to consider. It's something that should be made a part of the employer's work from home policy, expense reimbursement. In the workplace, if you're in an office setting, we all know that there are employment posters hanging up, and there are annual poster requirements, probably hanging up in the cafeteria or somewhere else in the office. Well, if an employee is working from home, there's also actually an obligation by employers to make sure that their employees are receiving the posters and receiving notices or annual notices that are required by either the federal or state laws. So there actually is, there have been recent guidelines issued by the Department of Labor, recent guidance, which holds that electronic notice is permitted if employees customarily receive information by electronic means and have readily available access. So again, as a reminder, it's an obligation in the office setting. It's also an obligation. Posters are also an obligation from the work from home setting. There's also a law that's it's actually a Department of Labor regulation, which talks about the continuous workday. And the continuous workday runs from the time the employee starts to work and goes to the time that the employee finishes work. And the employee has to be paid for that time. But there's also an exception where the employee is not entitled to be compensated for commuting time. So there's been a recent relaxation of the continuous work rule, and I'll give you it by way of example. So if an employee starts to work from home in the morning at 9 o'clock, spends 9 to 12 working from home, and then at noon decides to drive in to the office and spends an hour to commute, well, that commuting time is not compensable even though the employee started work that morning. And that's because of the Department of Labor's relaxation of the continuous work rules. So just bear in mind that that's also an issue as far as what constitutes compensable work time. It's actually viewed as a gift for employers because, again, this is the exception to the continuous work rule. The biggest takeaway from the work from home issues in the wage and hour world is, again, have the written policy, remember to track the employee's time, train supervisors to be vigilant. If employees need to work at night or on weekends, make sure it's the exception, not the rule, and make sure that time is tracked and make sure that time is compensated. Remember that these warnings, for the most part, deal with non-exempt employees, hourly employees. The rules are different for exempt employees, such as managers or administrative employees or professional employees. But it's just something to be aware of. And again, it's important to be vigilant on the wage and hour work from home side. One of the big issues we've seen, I'm going to now move on to accommodation claims. Employees could be entitled to work from home if they request if they're requesting it as a reasonable accommodation to a disability or to for a religious accommodation. So work from home is not automatically an entitlement to employees. If an employee has a true disability and working from home is a reasonable accommodation under the circumstances, then typically it will have to be granted. The analysis that has to be undertaken by the employer is the request for a reasonable accommodation is made. The employer is then obligated to engage in the interactive process with the employee to determine whether the employee can perform all of the essential functions of that employee's job while working from home. If the answer is yes, and the employee has a disability, then typically that request will have to be granted. If the employee cannot perform all the essential functions of the job, that doesn't necessarily mean that the request has to be denied. There may have to be, as part of the interactive process, a discussion about whether the functions that can't be performed by that employee at home can be reassigned to another employee and performed by another employee on a temporary basis. So, it's really, the interactive process is really unique because it's really a function of whether the essential functions of the job can be done with a reasonable accommodation. And working from home is not always the only answer. Also, with respect to working from home, the employer has to make sure that the employee is properly equipped to perform the essential functions of the job. So does the employee have a computer at home? Do they have a printer at home? Do they have the necessary office supplies to perform their duties from home? So that is something that has to be addressed as well. And by the way, that's also part of the interactive process, because if the employee doesn't have any of these items, is the employer required to provide these items? Does the employer then have to run out and buy a computer and buy a printer for that employee so that the employee can perform the essential functions of the job? The answer is maybe. The answer is maybe because if that expense, if that cost to purchase that equipment doesn't create an undue hardship to the employer, then the employer may have to go out and purchase that equipment and those supplies. And again, what constitutes an undue hardship? I mean, it is a cost analysis, but it's also a cost analysis based upon the revenue of the employer. Can the employer afford to buy this equipment, and would it create an undue hardship? So that's the analysis when we get into work from home issues. as I mentioned before, there has to be a true disability in order for the employer to have to engage in the interactive process. So if the employee comes to you and says, I am fearful of contracting COVID-19 in the workplace because somebody else, tested positive, general fears or anxiety about contracting COVID is not viewed as a disability. So again, there has to be a true disability in order for the employee to be entitled to the working from home as a reasonable accommodation. So that's what goes into the analysis of the work from home requests by employees. By the way, if anyone has a question, they can post it on the chat. I'm happy
Doug,
to.
there is one question here. It's in the Q&A section. It says, is there a recommended amount of reimbursement for use of the personal cell phone?
So all I could say about that is in California, it's a pro rata portion of their cell phone. I don't know what that means. And I haven't seen any cases that analyze what constitutes a pro rata portion. I mean, if the employee says, I use my phone 50% for business and 50% for personal, I don't know how the employer can really evaluate that other than asking for, a copy of their cell phone bills and analyzing, who the calls were made to or from. So I think it's just going to have to be, just a gut feeling and a fairness analysis. I think if it's reasonable, the employer may just have to go with whatever the employee says. But other than that, there is no pro rata. What does that mean? I did want to I skipped over one other takeaway on the wage and hour side, which I think is important. And because of the issue of tracking the employee's time, it's probably a best practice for employers to have the employees sign off on their work time on a daily basis. It seems like an easy thing to do. There should be an indication by the employee when they started, when they took their meal period, when they ended for the day, and if there was any extra work done, that should be indicated by the employee as well. And that way, if there's any potential, unpaid wage claim down the road, at least the employer at that point has, sufficient documentation to refute any claim by the employee. So, that's best practice and the best advice for employers to follow as well. Regarding discrimination cases, discrimination law. So, first of all, one of the first issues that arose out of the pandemic was for employers to be aware of disparate treatment of the vulnerable population. So actually at around the time the pandemic hit, the Equal Employment Opportunity Commission came out with guidance on this issue. So for example, if an employer has a 70-year-old employee, it's actually discrimination for that employer to require that employee to work from home because the employer is concerned that based upon the employee's age, that they're more vulnerable to becoming sick in the workplace or becoming sick from COVID-19. So that's actually discrimination. Same with, for example, a pregnant employee. While an employer may think that the employer is doing the right thing by requiring a pregnant employee work from home to avoid any issues from a commuting standpoint or an office setting standpoint, that's actually discrimination. It's not up to the employer to decide what's in the best interest of the employee. It's actually up to the employee to make that decision. If the employee, under those examples, want to continue to work from the office, understanding those risks, then they're going to be entitled to do that. So just beware of potential discrimination claims against the vulnerable population. Deciding who to permit to work from home is another issue, because this has created discrimination claims. Employees may view it as discrimination if the employer permits an employee to work from home and denies the right for another employee to work from home. So those decisions can give rise to claims for age discrimination or race discrimination or sex discrimination or national origin discrimination or disability discrimination. Another thing to keep in mind, if you're making decisions that you're permitting some employees to work from home and denying that right to other employees, make sure that those decisions are made based upon business justification, not based upon their particular class or their particular situation. It's also important as part of the work from home policy to remind employees that the employer's anti-harassment policies still apply to working from home. So employers have to remind employees not to harass each other, other employees through email, through texting, through phone calls. The anti-harassment laws, still apply. The workplace is still the workplace, whether they're working from the office or at home for anti-harassment purposes. The next issue, which we've come across in the work from home world, is that because the home is the workplace, employers have an obligation to keep the workplace safe. What does that mean? Well, there's the Occupational Safety and Health Administration, OSHA, has this general duty clause, which requires employers to provide a safe workplace for all employees. That's pretty basic, and most employers would assume that the workplace is safe. The home workplace is safe. But beware, because if an employee who's working from home trips on the way to the bathroom, that's going to be a workers' comp claim. If that employee develops some illness while working from home, that could be a workers' comp claim. So again, beware. And by the way, we've seen situations where, diligent employers will actually, require the employees to take a video of the workplace, and whereby the employer can then, actually view the workplace to see if there are any safety hazards that could potentially create liability. Obviously, wires across the middle of the room could create a fall hazard and a potential injury situation. So again, diligent employers will, remember to, again, to just bear in mind that the home workplace is the workplace for safety and health purposes and for workers' comp purposes. Speaking of working from home, also this is important from the potential liability standpoint. Aside from the workers' comp issue, employers want to make sure that their insurance coverage covers work from home. So not just from the workers' comp side, but from a general liability side. So if, for example, an employee is working from home and has a work-related visitor come to the home, and that work-related visitor is injured at the home, is that injury going to be covered by the employer's general liability policy? It's important for the employers, and believe me when I tell you that there are numerous exceptions to the general liability policies, and insurance companies will do everything in their power to try to have a claim excluded if they can. So again, it's important when employees work from home that the employers also consult with their insurance brokers to make sure they have sufficient and proper coverage to protect themselves against all claims. The next aspect of working from home is cybersecurity and protection of trade secrets. So needless to say, when an employee works from home, when employees work from home, they have remote access. They have the ability to connect to the employer's server. It's harder for employers to control. There could be a greater likelihood of data breaches. So, you know, employers are reminded to make sure that either their IT infrastructure is set up so that their trade secrets are protected and they can protect their, you know, proprietary information as much as possible with employees who work from home. Also regarding that is that employees, when they work from home, may have a tendency to use personal emails for business purposes and use Zoom calls also for business and personal purposes. So just the employer should bear in mind that that's an issue that should be recognized and potentially perhaps dealt with, you know, in the work from home policies, depending on the nature of the business. Again, it's important to make these issues, these IT security issues as part of the work from home policy, to have sufficient protocols to protect the employer. Social media policies, most employers that have employee handbooks will have a social media policy. It's important also to expand the social media policy to potentially include work from home issues. Regarding social media policies, employers are reminded that they can't prohibit their employees from discussing the terms and conditions of their employment on social media, as that would be deemed to be a violation of the National Labor Relations Act. But it is important to have a social media policy as well as part of the work from home policy. The last issue I'm going to cover on the potential minefields for employers are: how does an employer track the employee's productivity? We talked before about tracking time, but what about productivity? So there is software that's available to employers enabling the employer to actually go onto the employee's computer while the employee is on that computer and actually see what that employee is doing. It's a good idea. I would recommend it if the employee wants to ensure that their employees are doing the work they're supposed to be doing. But it's also important to advise the employers to understand that there are no privacy rights, that it would not constitute an invasion of privacy if the employer did choose to monitor the employees' work during the course of the day. Employers should be mindful that they have to be careful not to monitor the employees' work if the employee is on their personal email or performing personal matters in non-working time. So it's important to be aware of that issue. We've had employers that have actually set up little cameras in front of the employee's computer monitor, so the employer can actually see what the employee is doing and working on at any given time. Again, as part of the monitoring productivity and communications, it's important, again, to have the written policy to remind employees that the employer has the right to monitor their work and will do so. It's also possibly important, aside from having this work from home policy, to revise employee handbooks to include that issue as well as all these other issues. And again, as I mentioned, in the wage and hour world, it's important to train supervisors to understand their rights and ability to monitor the employee's productivity during the workday. That's what I have on the work from home issues, the minefields for employers. At this point, are there any questions? And when I say that, I'm actually going to move into, this is a bonus round for all the participants here today, because I'm going to talk about one of the hot issues in employment law, which is vaccines in the workplace. But before I get to that, does anyone have any questions about minefields for employers on work from home? Yes, there was a question as to whether you need to let the employees know that you are monitoring them. It's a best practice, but the answer really is a function of what the particular state's law requires. So in New York, for example, there is no expectation of privacy. There would be no right for an employee to claim an invasion of privacy if the employee was not informed that the employer would be monitoring their work. But nevertheless, it's advisable to notify the employees. Some states do require that notice be given. I believe California is one of those states. Next topic, as I said, I am going to mention, because again, this is an important issue, is vaccines in the workplace. So
real quick,
sure.
before you jump to that, in the Q&A spot that's beside the chat, there's one more question here. What if they use their own computer? Can you still monitor them?
Yes. Yes, because they're using their own computer, but on company business. So the answer is yes, but again, do it with a proper notice and notifying the employees that you have that right and you intend to do so.
Thank you.
Okay. And by the way, some employers will actually not only monitor, but install software which shows how many letters were sent out and whether that was the same amount of letters that were sent out when the employee was actually working in the office. So there's software out there which actually enables the employer to not only monitor, but actually see what they're doing at any given time, but evaluate the productivity on a quantity basis as well. So that exists. That's out there. Vaccines in the workplace. Companies may have the legal right to mandate that employees get vaccinated for COVID-19, according to the December 16th, 2020 guidance issued by the U.S. Equal Employment Opportunity Commission. Now, why did the EEOC say that employers could require their employees to become vaccinated? Well, it's because vaccines are not considered to be a medical exam under the Americans with Disabilities Act. Under the Americans with Disability Act, employees cannot require their employees to have medical exams, but vaccines are not a medical exam. So that's why they permitted that. But employers should be cautious because any pre-screening questions about a disability could be deemed to be a medical exam and could violate the Americans with Disabilities Act. So the actual requirement for the vaccine is not a medical exam. Potentially pre-screening questions about a potential disability would violate the Americans with Disabilities Act. But the EEOC also said that even though employers are permitted to require vaccines, the employees can request an accommodation under the Americans with Disabilities Act. So if the employee has an objection to taking the vaccine because of a disability, the employer again has to engage in the interactive process with the employee to determine, what the disability is, whether a refusal of the whether not requiring the employee to have the vaccine is a reasonable accommodation under the circumstances, and potentially under that scenario, permitting the employee to work from home instead of working from the office may deem to be a reasonable accommodation in order to accommodate the employee's request that they not be required to take the vaccine. There's also an exception for accommodation under Title VII for sincerely held religious beliefs. And the EEOC has actually said that if there is a stated sincerely held religious belief by an employee for not wanting to take the vaccine, the employer should assume that the religious belief is sincerely held, but the employer is not prohibited from actually questioning the employee and determining whether there is a true objective basis for that sincerely held religious belief. So again, that's another exception. Now we know that employers can require their employees to take a vaccine, and it doesn't violate the discrimination laws according to the U.S. Equal Employment Opportunity Commission. But should the employers require it? There may be if the employer has a belief that this is the best way to protect their employees and their business, then maybe they should. If there are other options to the employer, such as permitting employees who may object to this to take unpaid leave during some period of time, that's an option to employers. There are practical considerations also where an employer may require an employee to take the vaccine, which is if employees refuse to take the vaccine, what do you do with them? Do you fire them? Do you fire them en masse? We've had a situation with a nursing home recently where the nurses were actually refusing to take the vaccine. The employer didn't have the ability to terminate all the nurses, so they just walked away from the requirement. It's out there, it's an issue. There are practical considerations that the employer should take into account in evaluating whether to require it. One of the interesting issues also about requiring employees to take the vaccine is that the vaccines that have now been approved were actually approved under the FDA's emergency use authorization. And under the FDA's emergency use authorization, anybody who administers the vaccine is required to give a fact sheet to the employee, to the employee who's receiving the vaccine, and the fact sheet actually says that the employee can refuse to take the vaccine. So now you have the EEOC on one hand saying that the employers can require it. On the other hand, you have this FDA fact sheet that says the employee can refuse it. What would the courts decide under those circumstances if an employee refused to take the vaccine and was then terminated? I don't know. This issue is a legal issue. It's in its infancy. I haven't seen any cases that have any court decisions that have addressed this issue, but it's out there for the employer to consider if they want to implement a vaccine policy. There are obviously potentially employee morale issues by employer requiring the employees to be vaccinated. Employees may be upset with it. Employees may not agree with it. They may not believe in it, and it may affect employee morale. There are potential workers' comp issues. If an employee contracts COVID-19 and they believe they did so in the workplace, and they believe that if the employer had promulgated a vaccine requirement in the workplace, they would not have developed COVID-19, there's a potential workers' compensation claim under those circumstances. With respect to the workers' comp world in COVID-19, there's always an issue as to whether the employee can prove a causal connection to contracting COVID-19 in the workplace. You know, why didn't the employee get it on the subway or the bus or, you know, at the gas station or a restaurant? So you always have that issue, but there is a potential workers' comp claim. Also, there's a potential workers' comp claim if an employee has an adverse reaction to a vaccine if the vaccine is required by the employer. So again, that's another issue that's out there for employers to consider. With respect to union employers, if an employer decides to establish a vaccine policy, are they required to negotiate that policy with the union? If they implement a policy and they haven't negotiated with the union, and an employee is terminated for refusing to be vaccinated, would that constitute just cause under the collective bargaining agreement? Again, I don't know. There's an argument to be made there. We haven't seen any cases or arbitration decisions on the issue yet, but again, that's out there as a potential issue when it comes to employers considering requiring vaccinations in the workplace. You know, we've seen the employers that have established vaccination policies. Some are offering financial incentives. You know, could be pay, additional pay. It could be additional time off for taking the vaccine. We've seen software, we've seen HR software solutions that employers now have available to them to track employee vaccinations. But another practical issue with respect to requiring vaccinations is that the slow rollouts are actually complicating mandatory vaccinations in the workplace anyway. So, you know, it's not as if every employee can receive the vaccination, you know, at the same time or immediately. The rollout is going to take place over time, and it's going to be, obviously, everybody reads the newspapers. It's going to be several months until, you know, all employees who can be vaccinated will be vaccinated.
Thank you. And thank you, Doug Rowe. That was extremely informative, Doug, like always. I've known Doug for 25 years, which is disturbing. That fact is disturbing in itself. But it's hard to find someone is such a good person and so knowledgeable about areas of the law that he covers. So you know, and a more, really very hard to meet a more genuine person. So if you have questions and follow up, he's always open to helping. I know I've sent many people his way, and he's always open to helping. So if you have questions, please reach out. Thanks again, Doug, for your time today.
Thanks, Darren.
I'm Darren Port. I'm an associate member of the organization, like Doug and Ellie, and I'm the CEO of Powered by Professionals. We're a fundraising and event management firm here in New York City. We're a national organization based in New York City, and we've helped start 14 organizations from scratch over the last close to 20 years. and have raised over $140 million for different nonprofits that we work with. We work exclusively with nonprofits and help our charity partners with their fundraising and event strategies. We've taken them all virtual and hybrid over the last 12 months and are always open to talking to anyone who's part of the Nonprofit Resource Hub in helping you kind of navigate this complicated world we're living in. So don't hesitate to reach out. I will, I'm actually going to post in here in the chat. I'm just adding my information. If you have any questions, always happy to do a free consultation with anyone who's part of the Resource Hub. I will say, I did want to inform everyone there's a great event coming up for the Nonprofit Resource Hub on February 18th from 4:30 to 6 p.m. It's a nonprofit meet and greet. So this should be a great opportunity to network within the industry and meet some of the associate and board members of the organization. You can sign up directly from the website, or I think they're going to post it in the chat. Here it is. So you can just register right from that link. I want to thank you all for attending the webinar. We'll be sending out a survey to everyone. We'd ask if you would please fill that out, because that helps us as we create these programs. We have these programs going on usually, I think, twice a month. So there are different topics. I know I spoke back in the fall, but they're continually trying to cover all the different things that your nonprofit may need assistance with. So again, please visit the nonprofitresourcehub.org and for more information, becoming a nonprofit partner. Have a great day, everyone, and please stay well. Thanks again, Doug and Ellie, and everyone for participating.
Thanks,
Take
Dan.
care.